Could I have you say that one more? You've managed to mute yourself. Could you unmute, please?
Yes, I can hear you.
Okay, great. Could I have you count to 10 for me so we could get you up on our active speaker view?
1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Great. Perfect. Thank you so much. Okay, Mr. McCarthy, I'll ask you to please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, and then thank you. You can put your hand down. Because we're being recorded, I'll ask you to please state and spell your first and last name for the record.
Robert, Robert, Patrick, McCarthy, McCarthy.
Okay, all right. Whenever you're ready, defense.
Thank you, Your Honor. Good afternoon, Dr. McCarthy.
Good afternoon.
How are you employed?
Pardon me?
How are you employed? What do you do for a living?
Oh, I'm a urologist. I'm employed by the Grand Rhonda Hospital here in La Grande.
All right. And are you currently with us today, even though you're feeling ill?
True.
All right. I'm going to try to keep the questions to a minimum. Can you tell us whether you are acquainted with a woman named Andrea Jacobs?
I am.
And in what capacity did you first meet her?
Oh, I first met her. She was an employee in the medical staff department at the hospital.
All right. And let me ask you, where are you employed currently?
At the Grand Rhonda Hospital.
All right. Did you,
in La Grande.
prior to working for the hospital, did you run a private practice on your own? Did you have an independent practice?
I did.
All right. Did Ms. Jacobs work for you at some point in your private practice?
She did.
And can you tell us roughly what those years were that she was in your employ?
Oh, for about probably 15 to 20 years prior to 2015. So dating back to about that far.
All right. And you said that you're now with the hospital there in La Grande. Did she also work at the hospital with you later?
Yes, briefly after I dissolved my private practice and started working for the hospital, she was employed by the hospital as the urology clinic manager for a brief period of time.
All right. Now, why did you decide to transfer from your private practice to the hospital?
Well, because the practice was just failing financially for unclear reasons, but it was. And I finally decided to give up on that and sell my office building to the hospital and become an employee for the hospital.
All right. And after you did that, and I don't want you to give too many specifics, but after you did that, did you learn that Ms. Jacobs had a role in the failure of your practice?
Yes, I did.
Okay. Did you do some investigation into that?
I did.
And did that eventually result in her prosecution in a federal case?
Yes, it did.
Okay. And was she convicted of offenses in that federal case?
Yes, she was convicted.
All right. Based on those experiences in this long period of time that you knew her, were you able to form an opinion about her truthfulness?
I was.
What is that opinion?
She's extraordinarily untruthful.
All right. Thank you, doctor, and thank you for taking some time to be with us this afternoon. Sorry for interrupting you.
Okay.
All right, and before you leave, Dr. McCarthy, we'll see if the state has cross-examination.
No. Very good.
They do not, so you may disconnect. Thank you for appearing today.
You're welcome. Thank you.
All right. And is the next witness also via WebEx?
Yes, Your Honor. That will be Rhonda Slavik.
Okay. We'll take a moment to get her on screen.
Good afternoon, Ms. Slavik. This is the court clerk. Could I have you please count to 10 so that we can pull you up on active speaker screen in the courtroom?
Sure. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10.
Perfect. Thank you so much. I will ask you to go ahead and raise your right hand for me, please. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
I do, yes.
Okay, thank you. And then because we're being recorded, I'll ask you to please state and spell your first and last name.
Rhonda, Rhonda. Last name Slavik, Slavik.
And Ms. Slavik, this is Judge Ramrus. I saw the door behind you open slightly. I couldn't tell if someone was coming in or leaving or just realizing they shouldn't come in. But I just want to make sure that we're clear that you need to be in a room by yourself while you provide testimony. Is there anybody else in the room with you?
There's not. Somebody just got home and, yes, opened the door and realized you shouldn't come in.
All right.
So,
fair enough.
Understood.
All right, go ahead then, defense, when you're ready.
Thank you, Your Honor. Good afternoon, Ms. Slavik. Where do you live, just generally?
Santa Barbara, California.
All right, and is that where you are today?
It is.
Right. What do you do for a living?
I work in real estate development consulting on sales and marketing for real estate developers, condominiums.
Okay. Was there a period of time that you were living and working regularly in Portland, Oregon?
Yes.
During what years was that occurring?
From late 2007 to sometime in 2013.
Okay. During those years, did you meet a woman named Andrea Jacobs?
I did. She was my brother's business partner.
And during those years, did it come to pass that she ended up essentially living or staying regularly in the place where you were staying?
For a period of time, yes, she did.
And can you describe just generally, we don't need the address, but can you describe that living situation and how frequently you would see her during that time?
Sure. Because I was selling condominiums, it was a new building. I wasn't living in Portland when I was hired. I had a 2-bedroom apartment there. So my brother stayed with me and he had the other bedroom, and Andrea would come over to visit him, work. And when I was out of town, she also would stay over.
Okay. And roughly how much time would you say you spent with her during those years? I mean, how frequently would you see her? How often would you have dinner together or do things that were somewhat social in nature?
From 2008 to 2012, I saw her regularly when I was up there. I would say I was up every week. I'd see her 3 out of the 4 weeks that I was visiting. And she also spent some holidays with my family in Northern California.
All right. And as a result of the time that you spent with her, were you able to form an opinion about her truthfulness?
Yes.
What is that opinion?
In my experience with her, she's not capable of telling the truth.
Thank you. No further questions.
No. All right, Ms. Slavik, thank you for your time. You can disconnect.
Okay, thank you.
All right.
Your Honor, the next witness is Dr. Curtis Haney. His brother, who is also his lawyer, would like to be able to sit close enough that he can see his client.
Sure. Are they in the courtroom right now?
No, they're
Okay.
right outside.
So where are you proposing his brother sit? Just
Well,
what?
maybe where Ms. Burrows had sat
Okay,
earlier.
that's fine.
Would that work?
Sure.
You're
Right
going
up
up
there.
here.
Oh, I'm sorry. Yeah, Dr. Haney, we'll have you come and step into the witness box, but stay standing for a moment and get as close to the microphone as you can. My clerk will give you an oath in just a minute. And before we do, I know that your attorney is here. I didn't know if your attorney wanted to put his name on the record or just wanted to be present in case something came up. I wasn't quite sure.
Yes, both, Your Honor. My name is Eric Haney, Perkins Coie, bar number 98248 for the witness.
Okay, thank you.
Okay, I'll have you please raise your right hand. Under the penalty of perjury, do you solemnly swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth? Okay, then you may be seated and you may remove your mask. And then because we're being recorded, I'll ask you to please state and spell your first and last name.
I'm Curtis Haney, Cortishaynie.
Okay, and Dr. Haney, there is water there if you want any, but defense whenever you're ready.
Good afternoon, Dr. Haney. Where do you live?
Hood River, Oregon.
Lucky you. What do you do there?
I'm a general dentist.
Can you tell us just generally about your practice?
Yep. Once again, I'm a general dentist with a focus on sleep-disturbed breathing issues, headaches, migraines, and overall head and neck pain.
Okay. So you do the traditional dental work with maybe some more complicated procedures, is that right?
That's correct.
Back in 2019, were you trying to build the category of your work that was maybe a little bit more complicated?
That's correct.
And does that complicated part of your practice also have complicated billing?
Yes, we're typically doing dental billing as a dentist, but with these other kind of focuses is more medical billing.
Okay. Do you know a woman by the name of Andrea Jacobs?
I do.
And when did you meet her?
Spring of 2019.
And how did you meet her?
She walked in the door.
Okay. Had you been advertising for help?
No,
So she just showed up.
she did.
And did she mention a person that you trusted at the time?
Yeah, one of my original mentors.
In that initial meeting, you had a chance to talk with her.
Yes,
Is
I
that
did.
right? And did you hire her then?
No, we weren't ready for the training that she was
Okay.
going to provide.
What did you think she would be able to help you with?
Develop the medical billing component and be able to better assist our patients with getting coverage.
This complicated part of your
Yes,
expanding practice. When's the next time you saw her?
in August.
Of 2019?
Yes.
Okay. Had you called her and told her to come in?
Nope, she just arrived.
Were you surprised?
Yes.
Okay. What did she do after showing up that impressed you?
She provided, she stated solutions of what we needed.
Okay. With this medical billing piece?
Yes.
Was she able to train your other employees?
She was starting to train those employees.
Were you impressed?
Everything sounded perfect.
Okay. In 2020, did COVID affect your practice?
We had to shut down.
Okay. During that time period, did Ms. Jacobs offer to help you out?
She volunteered to assist me on the medical component.
Did she also agree to work in your practice for free?
Yes.
Will object, Your Honor. I feel like we are getting outside the scope.
I think we're getting pretty close, counsel. So I'll sustain the objection to that last question and ask the jury disregard it.
During the COVID period, was it just you and Ms. Jacobs
For
in
the
your
most part.
practice?
For the most part.
Okay. And so did you get the opportunity to have frequent contact with her in a way that maybe you wouldn't have had your practice had all the other employees there?
Yes.
When did Ms. Jacobs leave your employment? Do you remember?
I believe it's May 12th when I confronted her.
And after her termination, did you then work with law enforcement in a federal case?
Yes.
And we've heard about a federal case that was filed in 2020. Were you the victim in that case?
I was.
And the period in that case in which You were the victim. Did that run from 2019 until May of 2020?
Correct.
Have you had an opportunity to form, excuse me, an opinion regarding the truthfulness of Andrea Jacobs?
She's a compulsive liar.
I have no further questions. Thank you very much.
Any cross-examination?
No.
All right. Dr. Haney, you can step down. Thank you for your time.
Your Honor, I think that with the exception of having to take care of some exhibits that we talked with the court about, the defense would rest.
Okay. All right. We will, for the jury, what we'll next be doing is we're going to go over some administrative matters outside of your presence. Not entirely sure how long this will take, but we'll give you an update shortly.
Okay, we'll go off record and we'll mute for weather.
We'll go, here's what I'm trying to figure out. We will go through the exhibits first, and then we'll see whether or not we can get through the instructions. I'm assuming both sides' preference, and given the lengths of closings that I'm anticipating, is that closings be given on Monday? Is that a fair assumption? Do the side any strong feelings one way or the other, whether if we can come to instructions today, whether they be instructed today towards the end and then dismissed for the weekend, or would the preference be that they receive the instruction right before closing arguments? Does either side have a strong opinion on that?
Strong opinion, no. But
Okay,
I think it makes sense to give it to them before closing.
meaning the same day.
Yeah, because
Right.
then they've just heard it and they can kind of
Right.
apply those principles as they're listening.
Sure.
So,
Sure.
but not a strong opinion.
And I guess my other concern is typically when instructions are given, the alternates are discharged, and I would want the alternates held through the weekend to just.
Oh,
for safety.
that's a very good logistic
Very good.
point. So here's my inclination then. Whatever the instructions ultimately wind up being, I don't think they're going to be fairly lengthy compared to many cases. I think I'm inclined to discharge them for the day now.
Your Honor, with
Yes.
I'm just so nervous about not getting this to a verdict. Would the court mind bringing them back in and just giving them a strong caution about talking to others or responding to media over the weekend?
Absolutely.
Let's hold the ship together.
I can also tell them what we're doing, I mean, not in detail, but just explain to them that when they come back on Monday, they can expect to receive instructions for the case and then the closing arguments of the attorneys.
Thank you.
We can do that. Yeah, all right, so why don't we bring them back?
Okay, go off record and I will go over the reaction.
Yes. Oh, please be seated, everyone. All right, we just wanted to let the jury know that there are a number of things that we are going to take up outside your presence where I just don't think it makes sense to keep you here. When we return on Monday, you can expect that we will give you the instructions and then go straight into closing argument. And what we're going to do the rest of the day will help us to get to that point. So we are going to excuse you for the day, but, and I know I said this earlier in the trial, but I think it bears repeating. I haven't said it in a while. It's been a long road to get to this point, and I want to make sure everyone remembers that you aren't to talk about the case with anybody under any circumstances, even with each other, and not to look up any information about the case. So with that, we will excuse you for the weekend and see everyone on Monday. Why don't we go through the exhibit?
Okay.
Yep.
Why don't we go through the exhibits first, and then we can take up the instructions. And I'm assuming that's Ms. Weinmiller who's in charge of that?
About exhibits. Oh, I'm sorry. Your Honor, we actually were reprinting a few exhibits, and so I didn't bring the exhibit set up here. I do have the list. We could go through the list.
Would you prefer to do instructions first then? I'm not sure what we're doing with the exhibits. Is this just there some that weren't offered previously, or?
Asked us to redact them, I
Oh,
think.
Oh,
Yes, that's
I
why
understand.
they're not printed yet, because we're still working that out.
I see.
We made a first run at some redactions. I think 2 of the 5 are okay. We're getting printed ones, and we're going to confer on a break and
Okay.
try to get that straightened out. But she was just saying we can't hand you the exhibits.
Sure.
yet,
All right.
but we
Then
can-
why don't we deal with the instructions, and then we can come back to that. And does everyone have a copy of the combined instructions?
Yes.
So I'm assuming your page numbers are the same as mine, but page number 10, I think, is where we begin the instructions that I would actually read, and that some copy of which would go back to them. That starts with functions of the court and jury. I'm sorry, go ahead, Mr. Overstreet.
Sorry, I was just making sure. Oh, because the introduction's already been read, so.
Right, all the other stuff is the preliminary
Right,
instructions.
we were just making sure because we had interlineated the title of the charge.
Oh, I see.
That was made corrected, but I think that won't be an issue moving forward.
I did read the charge to them earlier.
Yes.
All right, so functions of the court and jury is the standard uniform instruction that both sides are asking for. And then we come to instruction evaluating witness testimony. I would read, in this case, all 6 factors. And then defense is asking for instruction 1006A, the vouching instruction. Does the state have any position on that?
We agree.
Okay, vouching will be given. And then the state is asking for 1008 inferences. Does defense have a position on that?
We don't object to inferences, but we are asking for our own inferences instruction that comes as a special instruction later on.
Oh, what, do you know what page that's on?
19.
All right, let me jump to that. Sorry. State have a position on that?
Yes, Your Honor, we're just asking that the uniform instruction be read. I think it's the uniform instruction for a reason. I think that's the appropriate statement of the law. I think the defense instruction is adding and expanding on the law that's not necessary.
And does defense want to speak to inferences?
Well, Your Honor, it's a correct statement of the law, and the 2 cases that were cited originally with the court, both State v. Blivens and State v. Bell, support this construction of the law. So there's no question but that it's legally correct. We believe that it's legally necessary in this case because this is a case that is almost exclusively circumstantial. And we have circumstances in which the state is asking the jury to infer murder based on things that it repeatedly said were possible. For example, that it was possible that a slide was swapped. It was possible that she'd bought bullets. It was possible that she'd gone to a shooting range. We have inference after inference after inference. And this isn't just the standard theft case or burglary case where the inferences that the jury's being asked to draw are singular and not a chain of inferences that the jury would have to follow in order to find guilt.
And you mentioned 2 cases, Blimen and Bell, but I don't see those anywhere.
Well, we actually had them cited when we offered the special instructions, but State B. Bivens,
Bivens.
yeah, is at 191 or app 460
Mm-hmm.
at pages 466 and 468. It's a 2004 case.
Okay.
And State v. Bell 220
Mm-hmm.
or app 266 at page 270. It's a 2008 case.
Okay. All right, I'm going to hold off and I'll take a look at those. And then I know at the beginning, I no longer recall, I know at the beginning I informed the parties that the court was going to give the reasonable doubt instruction that is listed in here. I don't recall if either side had an objection to it. We'll start with the state
No, Your Honor.
and defense.
Your Honor, we had objected before the court already gave the instruction at the beginning of the case. I guess we'll continue the instruction, although I think it would be strange to change courses.
Okay, so you had objected earlier. All right, I apologize, I did not recall that. Okay, and then we come to 1018, which is the subcategory classification factors and offense-specific enhancement facts.
Your Honor, which page are you on? I jumped down to the,
Sure,
Yeah,
I'm on page 14 now.
Thank you, I'm sorry. Okay.
And state has asked for that. What's the defense? And it looks like there's some modified language. And what is the defense position?
Like the modified language is just the allegation,
Oh,
is
it's
that right?
just it's just filling in the brackets.
Yeah.
Right.
Okay, I understand. All
I
right.
mean, I'll object for the fun of it, but I don't think it'll get me very far.
Okay. All right, I'll overrule the objection. Now, I don't plan to give 1021 since Mrs. Brophy testified. 1024, which is defendant statements, I would plan to give. Does the state have any position on that?
No.
All right. 1025, direct and circumstantial. I'm sorry.
So Judge, in 1024, there are sections where the language requested by state in the bottom paragraph is just as defendant, and then defense inserted Ms. Crampton Brophy.
I see. All right. So I guess the only difference between the two sides is the state is using the word defendant, defense is using her name. I guess I'll ask the state. Well, I assume your positions are the state wants me to use the word defendant and defense wants me to use their name. Is that essentially it? Or?
I think I've left in defendant, Your Honor. I just asked that our client be named since now we're talking about her statements.
Oh, okay. So the defendant, I see. So you're asking that I say the defendant, but then also say her name.
Yeah.
Okay. And does the state have a position on that?
We're not objecting. It's unnecessary because there's only one defendant, but
Sure. Okay. All right. I'll put her name in. That's fine. All right. So 1025 is direct and circumstantial evidence. The state is requesting it. I would plan to give it, but does defense want to make any record on that?
No, Your Honor, just renewed a request for the inference instruction, which I think fits with the circumstantial evidence instruction.
All right. The next is defense request for the less satisfactory evidence instruction 1030. State's position.
We're objecting to that, Your Honor. I don't think there is anything that can be pointed to where this instruction would be appropriately given in this case.
And defense, what would you point to? Or let me just put it a different way. Why do you feel the instruction should be given?
Your Honor, Ms. Weimiller and I included this instruction in the beginning because we thought we would have more evidence in regarding the destruction of evidence.
Oh, I see.
But
All right. So are you withdrawing the request or
well,
just?
we still have the fact that the DNA was not preserved on the crime scene casings. So there's still a loss of evidence that could have been really important in this case.
Sure. I'll allow you to argue that. I'm not going to give the instruction the way I view the instruction because it is close to a comment on the evidence that really, in my view, it's appropriate when there's evidence to suggest there was sort of a deliberate destruction of evidence or deliberate not obtaining of evidence, which I don't think the facts bear out here, but you can certainly argue. Both sides? No, we're not giving. Yeah, yeah. 1033, non-expert opinion evidence both sides are asking for. And then I don't know that I have a number for it, but, oh yes, 1034, expert opinion evidence both sides are asking for. So I'll give it. Before we move on further, I'm not sure where defense, if I give the defense proposed special jury instruction on informant testimony in some form, either as written or modified, where would defense want that to fall? It seems to me, since we're talking about witnesses right now, that it would either be directly before or directly after these other two instructions, but if there's some other place.
Perhaps right after the defendant's statements.
Okay, let me go back to that. Oh, okay, so right before the
nice
direct
bit.
and circumstantial evidence instruction?
Yeah.
Okay, and what is the state's position on this? And the reason why I asked the question earlier about whether you had had a chance to read it is, well, let me first ask, is there an objection to the instruction?
Yes, Your Honor.
Okay, are there particular sentences in it that the state objects to, or do they object to it as a whole?
Well, just if you can give us a second.
Right, well, yeah, and I'm not, if you want to take more time to read it and digest it, that's fine. I was a little surprised that you'd already had a chance to go through it, but maybe you were given it a long time ago, I don't know.
We weren't, but one of us had a chance to read some of the cases over the lunch break.
Okay. Well, why don't you tell me your objection to it?
Our main objection, Your Honor, is that there are certainly cases, though the majority of the cases that defense cites are not Oregon case law at all, and are from either other states or federal case law. I certainly think that when there's a cooperation agreement, or in the cases that are talking specifically about testimony of an accomplice in the case, or someone that has signed up as a cooperator who is getting a clear benefit for their testimony, that there are specific instructions that have been crafted for that. That is not the case here. Defense had the opportunity for rigorous cross-examination, which they certainly engaged in. All of her motives, Ms. Jacobs' motives, were explored by cross-examination. And the witness, evaluating witness testimony instruction already addresses some of the language in this exact instruction, specifically subs 4, thank you, or line number 4, which is that the jury
Evidence concerning the bias, motives, or interests of the witness.
Yes, and then 5, which concerns the character of the witness for truthfulness, and in this particular case, 6, which includes evaluating that the witness has been convicted of a previous crime in this particular case. Some of the case law that defense cites to talks about circumstances where there was a direct or clear benefit that was received by the person testifying. And in one case, well, 2 cases that they cite, again, it's related to accomplice testimony. In the Oklahoma case, Dodd v. State, that's a case that actually resulted in state law that requires a specific jury instruction and specific discovery rules related to the state of Oklahoma that derived from that. In the Banks case, Banks v. I think it's Retke, maybe. In that particular case, there was no jury instruction that was given And the jury was not told of the informant's continuing interest in obtaining law enforcement favor in that case, and the court still did not give the instruction. In this case, our case, the jury can infer that Ms. Jacobs had continuing interest, or if defense can argue that she did, though she said she did not very clearly. And they can argue as much as they want to about that because they had the chance to cross-examine her on that exact issue in multiple different ways, with the suggestion of multiple different cases, and were able to do so. And the instruction, I think that, so in this case, there's more that occurred in that cross-examination, and the jury had more information that they were able to consider than the jury did in the Banks case. And just like that case, no instruction was given, and no instruction should be given in this particular case.
You said the Banks case, I'm sorry, can you point me to where that is in here? I have not, just so both sides know, I haven't read this very thoroughly yet, and I certainly haven't read these cases. What is the Banks case? You've mentioned it a couple of times.
It is.
Oh, I see it. It's on the last page,
page
four. Okay.
or I guess not the very last page.
I
Banks
see.
v.
Dretke.
Dretke.
Got it. All right. I just wanted to make sure I knew where it was so I could take a look at it later.
Yeah.
All right.
Yeah, and so I think kind of ultimately what some of these cases talk about, and what our main objection is that it is a comment on the evidence. This proposed instruction is a comment on the evidence itself, and the evaluating witness testimony instruction that's already part of our instructions is sufficient to cover all the rest of the bases.
Okay.
Bases.
And defense, you've laid out your argument.
Let me just add a couple
Right,
of
sure,
words,
absolutely.
Your Honor.
Okay.
The state's argument is that she didn't get a benefit, but that really doesn't have anything to do with the witness's motivation. Detective Merrill's comments before this witness made any statements whatsoever was that this could be of direct value to her, as long as she made a statement that the prosecutor thought was helpful to his case. So that means that at the time that the statements that were originally made, that Andrea Jacobs was kind of strung along to believe that the police and prosecutors were going to help her situation. Once Mr. Overstreet informed her that there would be no deal or added value, the cat was already out of the bag, so to speak. Ms. Jacobs was left with this Hobson's choice. She either sticks to the lie that she delivered when she was motivated to lie, or she testifies in court that she lied to the police. Either way, her motivation to fabricate is very strong.
One question about what you said. I never heard anything about Mr. Overstreet telling her that her testimony would not result in any value. I'm not sure what you're referring to.
He actually examined the witness, saying, "You were told that you get nothing."
Oh, I see what you mean. Okay.
And apparently, he stated on the record earlier that they had told her, even before she testified, through her lawyer, that there would be no value headed her way.
Okay.
In any event, the issue is when she first makes the statement, what motivates her? She admits that she asked for a lawyer twice, and it's only when this promise of added value in exchange for statements that would be beneficial to the state that she makes the statement she does. So when she first makes them, her motivation to curry favor is very high. The fact that the rug gets pulled out from under her does not change her situation. It actually puts her in a worse situation. So now she's on the witness stand, and she can either continue to tell the lie under oath, or she can admit under oath that she previously lied to police. It's just a Hobson's choice, but either way, her motivation to lie is very strong. With respect to the case law, the actual language in our proposed instruction is from Oregon case law. The cases that are cited below have more to do with why a court should give an informant instruction, and we don't borrow any law from those cases.
Okay. How do you define, okay, all right, I think I understand. I do want a chance to read the cases before making the decision, so I will do that over the weekend. All right, let me jump back to where I think we were. Okay, I think we're at 1035, which is intentionally and with intent. And the state has filled in the language that would be in the brackets. Although, at least on the copy I have at the very end is something that's not filled out. It says, when used in the phrase intentionally cause the death of Daniel Brophy, another human being, intentionally or with intent means the person acts with a conscious objective to, and then it's left.
They gave me the language and
Okay.
Which one did you say?
I'm on page 17, line 15.
Oh, I thought Ms. Lou had said whether it was 2A or 2B, that's all.
Oh, I think she has the actual language. I don't know if she knows if it's 2A or 2B. All right, so bear with me and I'll pull it up. Why is it doing that? Okay. Oh. So the way it reads in the most recent version is, when used in the phrase intentionally cause the death of Daniel Brophy, another human being, intentionally or with intent means that a person acts with a conscious objective to cause the death of Daniel Brophy. Is that A or B? I don't know.
It's
Okay,
ours.
but
We own
that's
it.
what it will be then. All right. And then with regard to 1060 stipulated testimony, I don't know that there was any stipulated
There isn't
testimony.
any, we can remove that one.
Okay. All right, so we'll remove that. And then the next is 1061 stipulations of fact. I just don't recall. Were there any stipulations?
There was at least one stipulation of fact, and that was before trial began. The parties stipulated that on June 2nd, 2018, the OCI alarm was turned off at 7:22:30 a.m.
State agree with that?
Yes, with a slight addition that it was disabled by Daniel Brophy.
That's fine.
That's right.
Yeah, I
So
think
let me read back. So the state and defense have agreed or stipulated that on June 2nd, 2018, the OCI alarm was disabled by Daniel Brophy at, and you said 7:30,
7:22 and 30 seconds.
7:22
AM.
and 30 seconds a.m. Does that capture what the stipulation is?
Yes,
Okay.
Your Honor.
Yes.
And do you need me to repeat that?
7:22 and 30 seconds, a.m.?
Yes.
Yes.
Are you okay if I put it in this format?
I think it would be, yes, I'm fine with that. Okay. All right, and then we go on to 1063, which is the domestic violence instruction that the state is requesting. Any objection by defense?
Know that I have a legal objection.
I'm sorry, say that again?
I said, I don't think I have a legal objection.
Okay, all right, understood. I thought that's what you said, but I wasn't sure. And then I guess sort of the same question for 1064.
The same answer, Your Honor.
Okay, and we're not using the bracketed, correct? All right, so it's just going to read crime involving domestic violence and then the sentence that's after that. All right, and then as far as the instruction 1308 for murder, it looks like both sides are in agreement about that instruction. And the verdict form, oh, I'm sorry. So typically what I do with the verdict instruction, just so there's no confusion, I read every instruction except the verdict instruction until closing argument has finished, because that's sort of instruction to the jury on what they should now do since they're going to the jury room. So before we get into the substance of it, are both sides okay with the timing on it?
We are. Makes sense.
We
All
are.
right. And then with regarding the substance, it looked like you wanted to say something, Mr. Overstreet.
Well, I was sorry, Your Honor. I was looking back at the murder instruction. I think it should be clarified that it's murder in the second degree.
Oh,
And same thing in the first paragraph, the crime of murder in the second degree.
And the second,
Oh, and in the second paragraph.
yeah.
Murder
we-
in the
we
second
forgot
degree
that
in
one.
the first sentence.
Sorry, the title and the first sentence
And
and
the
the second
second
paragraph.
I just resent.
We forgot that one.
And I assume defense agrees with that.
Yes, Your Honor.
Well, the one you resent me, we need to get it in the second paragraph
Okay.
too.
Counsel, you sent it and it just,
That's okay. We missed the second one, or the third one, though, I can see.
Yeah, all right, well, we'll get that in there.
No, you did. I'm just saying we forgot it. Yeah. I always forget it.
So then, with regard to this final verdict instruction, is there any reason to have the bracketed portion, which is lines 12 through 17? Or I guess,
Yes.
okay, yeah, okay, yeah, right, okay. Any other thing to address with that instruction?
No,
As
Your
long
Honor.
as the unanimous language is in there.
Okay. Sure, of
And
course.
and it is.
All right. So then let me ask, let me ask about the best use of time now, because I know, Ms. Weinmiller, you had talked about getting redacted forms of the various exhibits. We could, I mean, we still have time, so we could take a break in order for you to do that, whatever. I mean, time is not of the essence right now, so however long you thought it would take to do that. Or if you think it's particularly time intensive or you just don't have the resources to do it here, we could re-adjourn a little earlier on Monday to deal with that. I'm flexible. I don't know how easy or hard it is for you to do from here.
Well, we'd actually done one draft and we need to compare language. If the court doesn't mind, there's an advantage to doing it now and that we
Sure.
can get nice
No,
instructions
that's fine,
printed
yeah.
and bring them Monday. If we just finalize it Monday, it's a little bit harder to get the,
Okay, let's deal with it now. I have the rest of the day, so what we'll do is we'll go in recess. I think what I'll do is just have you consult with the state so we can see whether or not there's going to be objections to the redacted versions, but I'm available and we'll just come back on the record when we need. I will tell the parties though that Ms. Liu does have to leave by 4. We can have another clerk here after that, but it may make things a little more confusing.
do you want to confirm the verdict form?
Oh, I'm sorry, then with the verdict form, yes, Ms. Liu was pointing out, I hadn't discussed it. I thought both sides were in agreement on the verdict form, but I guess I'll ask.
I haven't, have we seen a verdict form?
I don't know if you have or
We
not,
sent it before trial.
but we can certainly give you a copy.
Oh, I'm sorry, maybe not before, but I think when we did our first draft.
It was sent out by the state.
And you can look at that while you're going over exhibits if you want a few minutes to read through it and see what you think. Why don't we do that? Why don't we go in recess? Ms. Liu will let me know. But let me ask, are you going to stay in the court here to work on the exhibits or not? I'm just trying to figure out if she needs to be present in the courtroom.
No, and Your Honor, and the person who's making the copies may have misunderstood what quality of copies we needed.
Okay.
It could be, it's just 3 documents. I could forward them by email and we could just get them printed out here.
And
I
what's the
think it'll
best?
take 5 minutes after that.
What are we asking is
Yeah, I mean, I can just show you.
I just want to give, so just to make sure I'm understanding, are you asking us to print the documents?
I mean, we can go print them.
Or you can print them? If
Just
you
so
all are in
we're not
agreement,
waiting.
why doesn't the state print them? And how will they notify you when we're ready to have everyone come back into the courtroom?
Is this,
I can literally print it right now.
I'm just trying to understand, we're talking about the exhibits that would be admitted if they had been redacted, is this correct?
Yes.
Yes.
Talking about redacted versions.
I
yeah.
would just stay here.
Okay, all right. And I'm hearing this should be fairly quick anyhow, so, all right, I'll step off the bench then for however long it takes and then come back on.
We'll go off record and we are in.
And at the, and just, well, it's fine.
All rise.
All right, please be seated. And we're back on the record. Mrs. Brophy is not present. It's my understanding, defense, that she does not wish to be present for this
That's correct, Your Honor.
portion. And if I misstate the exhibit numbers, please correct me because I don't have them directly in front of me right now, but I did just read the 4 that had redactions, which I think were exhibits 114, 115, 116, and 117. 415, 416, 417, 418.
And 430.
I didn't see, I don't think I saw 430, so hold on. Let me get logged in. Oh, yeah, I did. Okay, so just to restate that, well, now it disappeared. Exhibits 415, 416, 417. Hold on, my computer is having problems here. Well, now it's just completely disappeared. I don't have it anymore. Not sure why it's doing what it's doing, but can you resend it to me?
Yes.
All right, 415, 416, 417, 418, and 430, subject to the earlier objections that the state made in my ruling. Is there any, my understanding is the sides agree with the redactions. Is
That's
that
correct, Your Honor.
all right? So those redacted versions will be admitted. That's my understanding, Ms. Weinmiller, that those will be printed out and brought on Monday.
And that's right, we just have a few last exhibits to get reprinted, including those 5.
Okay, I was going to suggest on Monday that we be here at 8:45 just to clean up some of these last minute matters before we bring in the jury for instruction, because I still have to rule on the defense special instruction, and then we'll have to print out whatever the final version is for everybody. Can everyone make it at 8:45, starting with the state
Yes.
for defense?
She's,
Sure.
can we? Yes.
Okay, all right, that's the schedule keeper, I see. All right, then that's what we'll do. We'll be adjourned until 8:45 on Monday. And Mr. Overstreet, go ahead.
Yeah, sure. And just a final note on the verdict form. It sounds like the parties
Oh.
agree on it, but
Yes.
I am going to add a line after the last question for the jury, which is the domestic violence
Yes.
portion. Just to specifically say, so leave it as it is, but then after the ORS is written, to say specifically that Dan and Nancy Brophy were married, since that's the only thing at issue, so.
And does it make sense to include the statute number since they're not going to be looking at the statute?
We don't have to. We could just change it to the state further alleges during the commission of this felony that the defendant and victim were married.
That would work for the court if it works for, okay, it looks like it works for defense. Let's just do that.
And I'll bring a new copy on Monday then.
Okay.
Oh, you've already changed it? All right, thank you.
All right, then we will see everybody on Monday.
Thank you, Your Honor. Have a good weekend. Thank you.
Thanks. You